Mr. President, Madam Vice President, members of the Court, it is a privilege, albeit a regrettable one, to appear before you on behalf of the Gambia on this application concerning the crime of genocide. My colleagues have addressed the evidentiary and legal prerequisites for the order on provisional measures that we seek, and my submissions now turn to the specific provisional measures we request and why they are needed. This court is the ultimate guardian of the Genocide Convention, and it is on you that the eyes of the world are turned today at this preliminary stage of the proceedings. The court's well-established conditions for the grant of provisional measures are amply met, as you have heard. This application is brought to protect hundreds of thousands of people from a multitude of acts that are genocidal. Back in 1948, the drafters of the Convention well knew the consequences of a failure to prevent acts of genocide. They created a system to allow steps to be taken to respond to a future genocide. That is why a convention was proposed. That is why it was negotiated and adopted. That is why Article 9 bestows a jurisdiction on this court to ensure that the obligations set forth in the Convention and the rights of the Gambia are respected, including by provisional measures. Mr. President, as you well know, this is not the first time the court has been asked to protect rights under the Convention. In April 1993, in the Bosnian genocide case, the court ordered the government of the FRY to take all measures within its power to prevent commission of the crime of genocide, and it did so by a unanimous decision. It also voted by 13 votes to 1 to adopt a further order addressing in particular the acts of military, paramilitary, and irregular armed units. 5 months later, it reaffirmed those measures and called for its earlier order to be immediately and effectively implemented. Mr. President, we do not wish to be back here in 5 months' time. Our hope is that the court will order provisional measures that are clear and specific. Our expectation is that Myanmar will comply fully with a binding order of this court. The provisional measures we seek are concerned, all of them, with genocide-related activity, as ad hoc Judge Lauterpacht put it back in 1993. As Mr. Reichler made clear, it's difficult to imagine many situations the court has faced in which the need for provisional measures has been more acute. The evidence before you, frankly speaking, is overwhelming. The risk of destruction of the Rohingya group, in part or in whole, is very real. In light of that evidence, it cannot reasonably be argued that there is no further risk of genocidal acts. And the further harm that is anticipated to occur cannot be undone or recompensed. As the court put it in the Bosnia case, and I quote, "No reparation could efface the results of conduct which the court may rule to have been contrary to international law." In the face of Myanmar's failure to give effect to a multitude of calls, repeated, to desist from acts that give rise to genocide, we submit that this court must act. And the question before you is not whether to order provisional measures, but what provisional measures to order. The Gambia seeks 6 provisional measures. The first and the second require Myanmar to act with immediate effect to prevent the further genocide of the Rohingya group. The third measure requires Myanmar not to destroy or render inaccessible any evidence relating to the events already described in the application. This is to ensure the integrity of the proceedings before this court and the proper fulfilment by the court of its dispute settlement function. The fourth and fifth measures require both parties not to take any action and positively to act to prevent any action which might aggravate the dispute or render it more difficult of resolution, and to provide a report to the court on implementing measures. And the sixth measure, which we made available yesterday, requires Myanmar to cooperate with the United Nations bodies that seek to investigate the acts that are the subject of this case. Each of these requests is based on the court's jurisprudence. Turn to the first two provisional measures. They are directed, Mr. President, to Myanmar's obligation to prevent genocide. First, by taking all measures within its power to prevent genocidal acts against the Rohingya group, and second, by ensuring in particular that any military, paramilitary or other organizations under its direction or support or subject to its control or influence do not commit acts of genocide against the Rohingya group. The written application sets out the specific acts which are sought to be prevented. All of them fall within the list of genocidal acts defined in Article 2, and as you have heard, there is compelling evidence that each of these acts has already been perpetrated and is being perpetrated right now against the Rohingya group by Myanmar or by entities acting under Myanmar's control or at its behest. Accordingly, the request for these two provisional measures goes to the very heart of the Gambia's application to uphold and to enforce the Genocide Convention and its rights under it to protect the Rohingya group against total or partial destruction. Mr. President, the measures requested are grounded in the recognition of, I quote, the value in humankind, end of quote. The idea that every human being is expected to have, and I quote, a value and dignity of her kind or his kind, end of quote. Those words will be familiar to some in the room. According to the United Nations fact-finding mission, regrettably, that is not the situation in Myanmar today, as far as the Rohingya are concerned. Indeed, in 2016, the State Councillor and Foreign Minister of Myanmar is reported to have insisted to the United Nations that it must refrain from even using the word Rohingya. And I quote, "We won't use the term Rohingya because Rohingya are not recognized as among the 135 official ethnic groups," end of quote. The agent's ministry affirmed that statement. The Foreign Ministry of Myanmar has simply refused to recognize the Rohingya as a group, and it has overtly sought to dehumanize the group and its members. In September 2018, the UN fact-finding mission reported on a communication from the Foreign Ministry that included links to 4 videos about the August 2017 events in Rakhine State. The 4 videos were each imbued with explicitly anti-Muslim and anti-Rohingya messages. The UN fact-finding report does not mince its words. It states, and you'll find it at tab 1, as follows. The State Councillor, Daw Aung San Suu Kyi, has not used her de facto position as head of government, nor her moral authority, to stem or prevent the unfolding events or seek alternative avenues to meet the government's responsibility to protect the civilian population. or even to reveal and condemn what was happening. On the contrary, the civilian authorities have spread false and hateful narratives, denied the Tatmadaws' wrongdoing, blocked independent investigations, including of the fact-finding mission, and overseen the bulldozing of burned Rohingya villages and the destruction of crime sites and evidence." End of quote. And the fact-finding mission is not alone in expressing these concerns. Very recently, the UN Special Rapporteur on the human rights situation in Myanmar has gone even further in her expression. The Gambia's application is premised on the view that the Rohingya group and its members are a part of humankind, and they have a value and a dignity, and that they are entitled to the fullest protections of the Convention from any act which is plausibly capable of being characterized as genocidal before it is too late. Given the evidence before the court as to what has already occurred, and given the length of time these proceedings are likely to take, the need for protective measures to assure the survival of the Rohingya as a group in Myanmar and the Gambia's rights as a state party to the Convention is pressing and urgent. The primary obligation arising under Article 1 of the Convention and the rights it creates is the duty on state parties to prevent genocide. That duty seeks to give effect to the words of Raphael Lemkin, whose book Axis Rule in Europe, published in the autumn of 1944, first coined the word. You will have it at tab 23, and this is from that first edition. Genocide does not necessarily mean the immediate destruction of a nation, he wrote. It is intended, rather, to signify a coordinated plan of different actions aiming at the destruction of the essential foundations of the life of national groups. It is not a single act, genocide. It does not occur at a single moment. It comprises different actions, the objectives of which include the disintegration of social and political institutions, followed by, as Lemkin put it, the destruction of the personal security, liberty, health, dignity, and even the lives of the individuals belonging to such groups. The intervention of a court, therefore, does not have to await the final moment, although in the case of the many thousands of lives of individuals belonging to the Rohingya group, that moment has already come and gone. Genocide is a continuum, and you are called upon to act now as acts of genocide have occurred and are continuing to occur. The ILC articles on state responsibility make clear that obligation to prevent a given act extends over the entire period during which the event continues, an approach the court confirmed in its Bosnian genocide judgment in 2007. The order for provisional measures we seek would require Myanmar to respect and comply with its Article 1 obligation. It is the only means to ensure that the rights of the Gambia and of the Rohingya group are further safeguarded under international law. It is the only means to ensure that the ability of this court to resolve the dispute is not compromised by further acts of Myanmar rendering the partial or total destruction of the Rohingya group in Myanmar a fait accompli. The first two provisional measures sought in this application are equivalent to those ordered by this court in the Bosnia genocide case, and they serve the same conservatory purpose. Here, as then, an order on provisional measures does not anticipate or prejudice the final judgment, and it is in conformity with the nature of interim measures because they are the only means to preserve the substance of the rights pendente lite. Furthermore, just as in that and other cases in which the court has considered provisional measures, irreparable damage is at risk here. You will recall, to achieve its protective function, and having regard to the experience in the Bosnia case, and in particular, and I emphasize this, the fact that the killing of 8,000 men in Srebrenica occurred 2 years after the court ordered provisional measures. The Gambia submits that something more is needed here, that the court's order should and must identify on a non-exhaustive basis particular acts of genocide, which the evidence shows have already been committed and which must not recur. As set out in the reports of the UN fact-finding mission and other bodies, these acts include extrajudicial killings, physical and mental abuse, rape and other forms of sexual abuse, the destruction of homes and villages, forced starvation, denial of access to medical treatment and humanitarian assistance, and restrictions on movement. In our respectful submission, your order must explicitly set out acts of a genocidal nature which are to be avoided and prohibited. Specificity of an order can only help to contribute to their non-recurrence. In the present appalling circumstances, the court's order, should we submit, indicate provisional measures of as great a specificity as possible. Only in this way can we hope that the rights of the Gambia and the safety of the Rohingya group be fully protected. Mr. President, I turn briefly to the third, fourth, fifth, and sixth provisional measures. The Gambia also seeks what might be called procedural provisional measures, with the aim overall of protecting the integrity of the proceedings before this court. The measures requested have several objectives. In particular, they will first contribute to the preservation and accessibility of evidence on the merits of the dispute. Second, prevent any aggravation or extension of the dispute between the Gambia and Myanmar. And third, assure the implementation of the foregoing provisional measures by providing for reporting on them within 4 months of their issue. To these measures, the Gambia has added a sixth provisional measure. This is necessitated by Myanmar's persistent refusal to cooperate at all with the United Nations fact-finding mission or any other independent fact-finding mission, including the UN Special Rapporteur. In particular, Myanmar has refused all such missions access to Rakhine State, to the scenes of the Tatmadaws clearance operations, or to the places where genocidal acts against the Rohingya are reported to have been committed. This deliberate effort to prevent access to evidence of genocide, which is documented in the UN fact-finding mission's reports, must not be allowed to continue during the pendency of these proceedings, because, we say, it constitutes an obstruction of the fair administration of justice, which it is the court's responsibility to ensure. And so, accordingly, as a sixth provisional measure, we request that Myanmar be ordered to grant access to and cooperate with all UN fact-finding bodies that are engaged in investigating alleged genocidal acts against the Rohingya, including the conditions to which the Rohingya are subjected. These provisional measures, the third through the sixth, are necessary to ensure that the court is properly equipped in due course to adjudge the merits of the underlying claim, including the facts, and to ensure that the dispute can be considered fairly and comprehensively by reference to all relevant material. The order is necessary where there is an evidential imbalance between the parties, since the acts complained of occur on the territory of Myanmar, which has the primary control of all the first-hand evidence. In such a case, where access to various areas has been prevented, the court, we submit, has a responsibility to ensure the fair disposal of the claim. Moreover, the indication sought will also assist in protecting against non-compliance or inadequate compliance, as so regrettably happened in the Bosnian genocide case. The Court has, in other cases that involve the rights both of states and individuals, required parties to inform it of the progress made in implementing its orders. We are not looking for an excessively active, continuing role in these matters, but given the gravity of the situation, given the likely length of future proceedings, and given, in particular, what occurred in Bosnia and Srebrenica after the Court's provisional measures in that case, we submit that the facts of this case call for a clear reporting requirement. Mr. President, to sum up, the indication of provisional measures is, we recognise, without prejudice to the merits of the underlying claim. Yet the evidence at this stage indicates grave violence and genocidal acts against the Rohingya group in flagrant contravention of the Genocide Convention and in breach of Gambia's rights. The consequences of not indicating clear and particularised specific provisional measures and not taking steps to intervene in Myanmar's disregard of its international obligations would, we fear, be very grave indeed for the Rohingya group, who remain at real risk of further genocidal acts, for the future effectiveness of the Convention, for the rights of the Gambia, and for the reputation of this Court, which is equipped with and must exercise its powers to afford an effective realisation of the rights under the Convention. That means we respectfully submit indicating the provisional measures sought by the Gambia, as well as any others in addition the Court might deem appropriate. The balance of equities points overwhelmingly in favour of far-reaching provisional measures. Mr. President, Madam Vice President, members of the Court, many in the Great Hall today, which happens to be International Human Rights Day, will have read a fine book with the title "If This Is a Man" by the Italian writer Primo Levi. It was published in 1947. You will find the relevant extract at tab 24. In the preface, Primo Levi recorded a concern which might be said to be of universal application. He wrote, and I quote, "Many people, many nations can find themselves holding, more or less wittingly, that every stranger is an enemy. When this happens," Primo Levi continued, and I quote, "when the unspoken dogma becomes the major premise in a syllogism, then, at the end of the chain, there is the lager." In the case of Myanmar and the Rohingya, when it comes to the merits, this Court will have the authority to break that chain. In the meantime, what you have is the power of interim relief, and we place our hope in your willingness to fully discharge your judicial responsibility and powers. Mr. President, members of the Court, I thank you for your kind attention. This brings the Gambia's first round to a close.